Good afternoon, everybody. Good afternoon. My name is Boluwatife Udiyomi, and I'm your host for today's session. Good afternoon, everybody. Please kindly indicate in the chat box and please kindly engage with each other while we wait for others to join this session. Thank you very much for joining today's session. Is going to be a very, very insightful session as we will be doing our legal advisory and we're going to be talking about investor agreements. Please engage in the chat box while we wait for others, and we'll be starting at 12:10 sharp. Thank you very much. Good afternoon, everybody, and welcome to today's session. Um, Please let's engage in the chat box. Please indicate if you can hear me clearly. Good afternoon, everybody. Welcome to today's advisory session. This session promises to be a very insightful session, and we are going to be having our legal advisory today, and the topic is investors' agreements, protecting your rights when involving external investors in your business. So this is a very crucial topic because in our businesses, we would want to have investors. And in this advisory session, we will be speaking about how to protect yourself when you are inviting or bringing in external investors to invest in your company. That way you are protected and then you have agreements that are binding you. So for today's advisory session, we are going to be, our facilitator for today is Ms. Odunayo Ibitoye, an associate corporate and commercial law practice group, Templars. Please, let's engage in the chat box, and please, can you please indicate that you can hear me clearly before we continue?
Yes.
Good afternoon, Mr. Abdul Kudus. So before we go into the session proper, I'm going to just take you through what LSETF does. LSETF, the full meaning of LSETF is Lagos State Employment Trust Fund, and it was created by the Lagos State Employment Trust Fund law in 2016. What we do is that our main mandate is to create jobs in Lagos State and curb unemployment in Lagos State, and then increase and help build the GDP of Lagos State and the economy of the country at large. So my name is Boluwatife Odiomi once again, and I work with Business Support Unit. And what we do at Business Support Unit is that we do capacity building. We help with access to markets. In capacity building, what we do is we basically bring platforms like this where we where we do our advisories and then master classes, and that way we are able to educate business owners on the things that they are to do for them to make their businesses grow, and those things that they are supposed to do to make their businesses thrive in Lagos State. And then we have loan facilities that we give at LSCTF. We have the nano loans, we have the ME loans, we have the MES loans, and we have the SME loans. And then our loans ranges from for MES we have 50,000 to 250,000. Then for ME we have 50,000 to 500,000, and then SME we have 501,000 to 5 million naira. Those are the loan ranges we have at LSETF for now. And then at Lagos Innovate, for any of our beneficiaries that are tech driven, so Lagos Innovate is the place for you to be. We give tech loans, we give workspace vouchers where you are able to get a voucher that you'll be able to work at workspaces, and then that way we help with job creation in Lagos State. So that being said, I would call on our facilitator, Miss Odunayo Ibitoye, to take up this session from here. And I promise you this is going to be a very, very, very exciting and very interesting session, as you are going to be learning a lot, and then you'll be able to make do with it in your businesses. Thank you very much. Miss Odunayo.
All right. Thank you so much for the introduction. Good morning, everyone. I'm really excited to be here. As she has said, my name is Odunayo Ibitoye. I'm a lawyer with experience in corporate and commercial law. So basically, my day-to-day activity involves working with entrepreneurs, business owners, basically just helping them navigate the legal side of running their business. So you would see things like drafting contracts, reviewing contracts, advising on compliance, and then structuring deals. So I'll be facilitating today's session, and my major goal is to make this discussion as practical and engaging as possible. So that everyone can walk away with insights that you can actually apply in your business. So please feel free at the end of the session to ask me questions or share your experiences as we go along. So this session is really for you. So the more interactive, the better. I'll be sharing my slides right away. I just need us to confirm if we can see my screen. Please, can you confirm that you can see my screen?
Yes, we can see your screen, Miss Odunayo.
Okay. All right, thank you. So I'm trying to put it in presentation mode now. Might take a few seconds. So we'll just wait for that to kick in. Okay, great. So today we're going to be discussing something really interesting. And it's basically investor agreements. Pardon me. Investor agreements, protecting your rights protecting your rights when involving an external investor in your business. So this is very crucial, specifically for business owners, whether it is small, medium, enterprise. It's very important that you protect your rights whenever you're dealing with external investors in your business. As we all know, a lot of businesses would need investments. Think about small businesses like someone selling chin chin by the side of the road, or think about someone running a hotel to multi-million dollar companies like Dangote, like BU, etc. Every business really needs an investment, and it's very important that whenever you enter into agreements with people that bring in capital to your business, you understand the terms of those agreements and you're able to pitch yourself and protect your rights effectively. So even before we go in, I'd just like to clarify that investment is basically the commitment of your current financial resources in order to achieve higher gains in the future. So definitely anyone that is coming into your business to give money expect some sort of return, and they would also want to protect their rights. At the same time, you as a founder or an entrepreneur, we're going to be using the word founder a lot, would also want to ensure that your business is protected. So going straight into the content of today, we're going to have an introduction into what this topic really is about. Then we'll consider why investor agreements matter. Talk about types of investment that are available in Nigeria, but as you will see, we'll focus on majorly two. Then we'll go into the nitty-gritty of investment agreement. So we need to understand the content. Then I'll be sharing tips for ensuring your rights are protected. Look at a case study on investor dominance that happened in Nigeria, have our conclusion, and I'll be more than happy to take all of our questions and provide answers. Now, going straight into the introduction, just like I said before, that when Nigerian businesses invite external investors, they are often seeking more than just financial support, right? Investor brings in critical capital needed for expansion, and they also open doors to new markets, strategic partnership, and industry expertise. In simpler words, investors bring a lot of benefit to a business. It can be someone selling chin chin in nylon, wants to evolve their business into something more serious and wants to start selling nylons. From then on, they want to start selling in plastic. From then on, they want to start shipping to other states. From then on, they want to start shipping out of Nigeria. So basically, investors help us as business owners to expand our businesses, right? And also open doors to new markets. Now, this injection of resources can transform a small or growing company into a very competitive player. However, these benefits rarely come without conditions, rather. Investors will want to exert some type of influence over how the business is run. And then they will also want you to assure them that they're going to get a fair return on the money that they've given, because it's not Father Christmas, it's not a charity, it's business, right? So without a proper framework, these expectations can clash with the founder's vision and control of the company. So imagine an investor comes and starts giving you condition that in order for me to drop this money or to make this investment in your business, I'm going to be taking 50% of the profit. I'm going to be taking 70% of the profit. Then my family members as well you also make sure that for 100 years, as long as my family name remains on earth, you must also give my family profit and stuff like that. May sound exaggerated, right? But we just see how a clash can happen between um, a founder's vision and control of the company. So this is where investor agreements become really essential. What do? They basically set out the rules of engagement, define each party's rights and obligations, create mechanisms for decision making, profit sharing, and dispute resolution. More importantly, what they do is help us strike a balance between protecting the investor's interest, rightly so, because investor is bringing in something into the company and expects a return, and also at the same time preserving the founder's ability to steer the business in line with their original mission. So in our presentation, we're going to outline what every entrepreneur and business owner in Nigeria needs to know about compliance, its benefits, and the practical steps to ensure your business stays relevant. Sorry? Can we hear me?
Yes, we can hear you.
Yes, we can hear you clearly.
Okay. So moving on, we're going to be discussing what an investor agreement is and why it matters. So an investor agreement is basically a legally binding document between a business and its investor that sets out the terms of the investment and the rights and obligations of each party. So it typically covers how much is being invested, what the investor receives in return, shares, debt, or convertible interest, instruments. Also sets out governing rights, profit sharing, exit option, and dispute resolution. So when we really ask ourselves, why does this matter? The number one reason why it matters is because it helps the parties to have clear terms. So this brings us to our first point, which is clarity of terms. An investor agreement clearly sets out the amount that is being invested, the type of investment, and what the investor receives in turn. So basically, the terms are clear. We are not assuming anything. We are not inferring anything. A, B, C, D, E, F, G is what we have agreed on. A, B, C, D, E, F, G is what is going to be enforced. So this basically takes out ambiguity and ensures that both sides know exactly what has been agreed. This takes us to the next point, which is protection of founders' rights. For entrepreneurs, agreement allows you to kind of define the boundaries of investors' involvement, allows you to protect your right as an owner, ensure that you're still taking control of your company. It can also help prevent investors from taking excessive control of daily operations while still giving them fair oversight, right? Because as I've been emphasizing on, is the fact that we need to ensure balance. Investors want to get a return on their investments, and at the same time, a business owner wants to ensure that their rights are protected. So investor agreements can help you do this. The next point is that it protects an investor's interest. I think that even goes without saying. Investors also don't just want to create a charity, right? They want to ensure that their interests are protected. They want to ensure that they get returns. So investor agreements would help set out these terms that ensures that founders' rights are protected and investors' interests are protected as well. The next important point is conflict prevention and resolution. So investment agreements will also help you to prevent conflict. Number one, because terms have already been clearly defined and outlined in the agreement. And secondly, what this does is that even when dispute arises out of an investment agreement, the agreement itself sets out how you can resolve this dispute. Then the last point is business stability and investor confidence. So when your investment agreement is well structured, you kind of signal to an investor that you're serious and you're very professional. So what this does is that it reassures investors that the business is managed transparently, making it easier to attract funding. For the company, it ensures stable and predictable relations with investor. I think I would also want to emphasize on the word predictable. It's very important that the terms that are guiding an investor and a business owner is very predictable. You know what your obligations are, you know what the rights are, you know what the investor's return is. It's clearly defined. So it makes your relationship extremely and utterly predictable. Now, the next thing we are going to be considering is type of investments in Nigeria. So we have three major types of investment in Nigeria. This is not an exhaustive list, but this is like the most common. So the first type of investment you can have is something called an equity investment. And what this does is that what you grant to an investor is a share in your business. Basically, the investor becomes a co-owner of the business. The investor's rights and obligation flow from the shareholding structure, something called the company's articles of association and shareholder agreement is in place. So when you think about an articles of association, think about a document that basically provides rule on how a company is run, right? So it's an agreement between the members of a company and the company itself, because in law, there's something called legal personality, which basically means that a company is a separate entity from the owners, from the shareholders. So equity just basically means that an investor is coming and is purchasing shares in your business, in your company. And what this does is that gives the investor and ownership stake in your business. So one thing you would have to look out for in equity investment is that, the major point is that equity investment provides long-term capital and it's often strategic guidance from investors. However, what it does is that it dilutes the founder's ownership. It dilutes founder ownership. And another risk is that excessive dilution or granting disproportionate rights can lead to loss of control for a business owner. So let's just think about a company as 10 slices of pizza. As the founder of the company, you've given yourself 7 slices. An investor comes and buys 2, another investor comes and buys 1. So you still have 7 slices of your company. What this kind of does for you is to allow you to kind of control your business, to determine a lot of administrative issue, management issues, etc. However, imagine a scenario that comes in where there are 10 slices of pizza. An investor comes in and says, I want 7 slices. You get 1, another investor gets 2. So that's what we mean by dilution of control. So that's basically the nature of an equity investment. Now let's talk about debt investments. So just think about debt investments as your basic loan, right? Approaching a bank that gives you loan, or approaching an investor, maybe an angel investor that gives you a loan to run your business. And usually the profit that they get is something called an interest, which is usually over a defined period. Now, unlike equity investment, the investor, which is usually the lender, it does not obtain any form of ownership rights in your business. So debt arrangements in Nigeria are basically governed by contract law principles under Nigerian law. Now, where the debt is provided by banks or a licensed finance house, the transaction would typically need to comply with regulations of the Central Bank of Nigeria, particularly relating to lending conditions, interest rate caps, and foreign exchange controls if the debt originates from offshore. Now, what you have to consider as a founder, understand that debt does not dilute ownership, but it creates repayment obligations that may strain your cash flow if the business is not yet profitable. In simpler terms, imagine you collect a loan from an investor of, let's say, 5 million naira, and the interest rate is 50%, right? Your repayment plan can be spread over months or spread over years. And where the interest rate is too high, it can actually strain your cash flow, right? Especially when your business is not yet profitable. So as a founder, it's required that you consider whether the business can sustain the repayment schedule without jeopardizing operations. It's something that we're still going to discuss at length in the course of this presentation. Now, the last type is hybrid. So think about it as combining equity investment and debt investment. But typically, it starts by debt investment, where people grant loans to persons, have repayment schedules, then have agreements that over a course of year, I would like to convert this interest that I'm supposed to get from you into shares or ownership in your business. And examples of these are something called convertible notes and simple agreements for future equity. Now, convertible notes, they are structured as loans that can later convert into equity, usually upon occurrence of a trigger event, such as a subsequent funding round. Might sound a little bit technical, but just think about this. Mr. Ade gives Mr. Chuka 10 million naira and says, oh, you're going to be paying me back 500,000 naira monthly, inclusive of the interest rate. But at some point, Mr. Ade and Mr. Chuka agree that, okay, maybe after 2 years, rather than paying me back the loan, I would like to use that money to obtain a share of ownership in your company. So this is basically what convertible notes envisage. The next one is SAFE agreement, SAFE agreement. So they are more straightforward contracts that give investor the right to obtain equity in the company at a later date, typically when a valuation is agreed in future financing. So they are simpler and faster to execute. Now, when it comes to hybrid instruments, what should you consider as an entrepreneur? Note that hybrid instruments delay valuation discussions until the company matures, which can protect founders in early stages. However, if poorly negotiated, they may convert into large equity stakes at unfavorable terms. Now we're going to go into the next thing, which is understanding the content of key investor agreements. And our presentation is going to be focusing on debt and equity investment. Remember, as I said before, equity investment is basically buying ownership, while debt is basically granting loan with certain repayment terms. And against this background, we're going to be looking at two major types of agreements that are peculiar to equity and debt investment. The first one is the shareholders agreement, and the second one is a loan agreement. So, shareholders agreement. What is a shareholder agreement? A shareholder agreement is basically a private contract among the owners of a company, including the founders and investors who hold shares. Now, what are shares exactly? Shares are basically a share of ownership in a company that usually have monetary value, right? So when a company, just as I said before, we have 10 slices of pizza, founder and two different investors that own a share of the company. So those three persons are who we refer to as the shareholders. In simple terms, they're basically holding shares in the company, right? So when the three persons come together, and they enter into an agreement that sort of regulates their relationship, their rights and obligations towards one another. This agreement is what we call a shareholder agreement. As I said before, I mentioned articles of association, I have defined it, says that while it sets out general rules for how a company is run, the shareholder agreement goes much deeper, basically spelling out the rights and obligations of each shareholder. Now, we're going to take a deep dive into key terms that we need to understand whenever you're entering into a shareholder agreement with your investors. The first one is governance structure. In a shareholder agreement, this section basically sets out how directors are appointed or removed and how the board is composed. I'm sure you're probably wondering, why is this necessary? So management is one of the most crucial arm of a company. As I said before, companies are legal persons, meaning that you can do things on behalf of a company. A company is a legal person recognized under the law. But at the same time, it's not a physical person that has a arm, that has a brain, that can make decisions. So what really the part of the organ of the company that makes decisions is what we consider as the management, which is comprised of the board of directors. So board makes approval for so many things. Board makes appointment of certain key employees, you know, board approves a lot of things. And so it's very important that in your shareholder agreement, you set out governance structure. Who has the power to nominate directors? Who has the power to appoint this specific kind of director? So in the Companies and Allied Matters Act, which is the law that regulates companies in Nigeria, it basically says that the first directors will be named by the member in the memorandum of association and later on appointed at the annual general meeting. So the agreement can give investors specific rights to nominate directors and require their consent for major decisions. This ensures clarity on who controls the company and how decisions are made. So in your shareholder agreement, you want to look out for, can I, as a business owner, appoint a director? If so, can I nominate a director? If so, how many can I nominate? Who has the overriding power to make certain decisions concerning certain matters? So this is something that you really, really need to look out for in your shareholder agreement. The next thing is called a preemption right. Apart from the fact that the Companies and Allied Matters Act already kind of protects this right, but it's also very important for us to understand this, right? So what does preemption actually mean? Preemption basically means that you have the first dib, right? So if your company wants to share new shares, old shareholders get the chance to buy them first before outsiders. That is how simple it is, right? It's basically you saying, don't dilute my ownership without giving me a chance to have a slice of the cake. So let's assume we have a very small pizza. Let's say it's 24 inches, and then our company wants to expand to 50 inches. There are more slices for more persons, but because you already control a percentage, just like I gave the other time, 10 slices of pizza, you already control 70%, right? But now we are extending that company. What this preemption right basically says is that as long as you're an existing shareholder, when the company wants to issue new shares, they have to first offer it to you in proportion to your current holding. So, a shareholder agreement can expand on this by adding rights of first refusal on share transfers or anti-dilution protection, ensuring that investors' percentage ownership is preserved. So, this is something that you would want to look out for. Another thing is called reserved matters. So, reserved matters are major company decisions that cannot be taken by management or the board alone without the approval of shareholders. So, and it would typically require majority or unanimous consent of shareholders. So, you want to look out for what are things that, excuse me, what are things that are important to you as a shareholder in a company. What are things that are important to you as a shareholder in a company? What are the matters that you would like for shareholders to have decisions on? Even though there are directors in that company, some of those issues that are protected under CAMA are issues like issuing new shares, altering share capital, amending the articles of association of your company, mergers, or selling significant assets. And one thing that I really want to emphasize on is selling significant assets. CAMA actually does, when I say CAMA, I mean the law that protects, that guides companies, that regulates companies in Nigeria, actually has a provision where it says that is for certain property transaction where a director will be selling his property to the company or the company will be buying the property of a director, you actually need the consent of a shareholder. So as a business owner, you want to really look out for most of these things where people can try to take advantage of a business by benefiting, or where there are issues of like conflict of interest, and negotiating for yourself that certain matters be considered reserved matters that mandatorily requires the assent or consent of shareholders in the company. Now, the next thing we're going to be discussing is share transfer. So basically, it specifies procedure for selling shares, for transferring your shares, and as I said earlier, there's a requirement that shares are offered to existing shareholders before outsiders. Right. The next clause I'll be discussing is dispute resolution clause, and this is actually a very, very important clause the in a shareholders agreement. So basically, when an investor who is a shareholder and a business owner as well, when you have dispute, how is it resolved? When you have dispute concerning shares or concerning ownership of the business, how is it resolved? This is where a dispute resolution clause spells out for you um, to resolve disagreements efficiently and avoided protracted litigation, especially given local court delays. So what this does is that you can bring in something called alternative dispute resolution that could be mediation or arbitration. And benefits of these ADRs is that they kind of provide you with privacy. You don't have to go to court where court documents are public records. They give you privacy. Also make sure that when a disagreement happens, people just don't resort to the court as the first step. If we've agreed that we are going to mediate our issues, mediation shall it be. We agreed that we're going to take it to arbitration shall it be. We say conciliation shall it be. So this is basically what a dispute resolution clause does for you in your business. I'm trying to move to the next slide, but it is not okay. Great. So now we're on loan agreements. So loan agreements are very simple, basically a legally binding contract between a lender and a borrower that sets out the terms and conditions under which money is lent. and must be repaid. As I said earlier, I gave the example of something called a debt investment. And the major type of agreement that you would come across as a business owner is a loan agreement, right? So you set out condition between a lender and a borrower, agree on terms and conditions. Then we'll be looking at key clauses to look out for. Number one clause that you would typically need to look out for and really, really understand is your loan amount, interest, and repayment terms. In any loan agreement, these are the most important clauses that you have to look out for. What is the loan amount? The loan amount is basically the sum the lender agrees to provide. Now, founders should not just look at the figure on paper, but confirm the actual sum they will receive after deductions. Deductions in terms of taxes that would apply to that loan amount, right? Lenders often charge arrangement or commitment fees upfront, so the net disbursement may be less than the stated amount. Knowing this upfront avoids cash flow surprises. So basically, you need to understand the loan amount, not just what is on paper, but how much is actually going to get into your pocket. After deductions like taxes are made, charge arrangements or commitment fees that your investor has actually charged you, right? So you need to understand that you need to ask questions and ensure that this is available in written form. The next thing that we're going to be looking at is interest. So interest is basically what your lender benefits from loaning you the money. So let's take, for instance, you are loaned 1 million naira and the interest on that loan is, let's say, 20%. So the 20%, which is 200,000 naira, is actually the benefit that your investor gets. And what they do is basically spread these payments over a period of years. So interest may either be fixed, it may stay the same for the duration of the loan, or it may be variable, meaning that it can change with market conditions. So these are terms that you would really, really need to look out for. Understand, am I just going to be paying you 10% for 5 years where I have to repay the loan? Or is it that it's going to keep increasing 11, 12, 13, 14, 15 for the course of 5 years where this loan for when I'll be repaying this loan. So understand fixed interest, understand variable interest. Variable interest rates always carry the risk of increasing unexpectedly, which can make repayments harder. So you have to pay attention to how the interest is calculated. Another key issue that we need to look out for is the repayment terms. And what repayment terms basically set out how and when the money must be paid back. So repayments may be spread out in installments or structured as a lump sum at the end of the loan period. So founders need to make sure that the repayment schedule aligns with their business's cash flow, right? When we talk about cash flow, it basically means money that is available for you to run your business. So look at the repayment terms. Can your business really take paying back 100,000 naira every month? Is that a term you want to renegotiate with your investor? So for instance, I gave the example of a startup that needs time to build revenue. You want to avoid loans that require immediate installments. It is also important for you to check if there are any penalties for early repayment or if the lender can deduct repayments directly from the company's bank account, which could actually affect your liquidity. Another key term you should look out for is security/collateral. Something that I sort of emphasized previously in the beginning of this presentation is the fact that debt financing for investor is a business for them as well. They also need assurance that you're going to pay back, apart from the fact that they would have done their due diligence on your business. You may have submitted proposals to them. They may set perhaps maybe targets that you have to meet for them to keep financing your business. One key issue is also security/collateral. So this is the asset a borrower pledges to assure the lender that the loan will be repaid. Take, for instance, you cannot want to collect a loan of 100 million naira. I want to use maybe a bicycle as a collateral, right? Collaterals would typically be proportionate to the loan amount that you've taken out. So it may include your company's property or equipment, receivables, or even personal guarantees from the founders. Another thing you need to note is that charges over your company assets must be registered with the Corporate Affairs Commission, and this is provided under Section 197 of the Companies and Allied Matters Act. To protect themselves, entrepreneurs need to focus on 4 key issues when reviewing collateral clauses in a loan agreement. 1, clear definition of collateral. It's advisable that you limit them to business assets. Another thing is release clause and proportionality. I already talked about proportionality. Something that I want to emphasize on is release clause. You want to be careful to look at your agreements carefully to make sure that the collateral that you've pledged and upon full repayment of your loan term, it is released back to you. So you don't want a situation where you've probably agreed that, oh, at the end of your repayment term, the collateral becomes the property of the investor. Now, another major clause that you need to look out for is something called a default clause. And what this clause does is that it defines the event that allows a lender to declare that the borrower is in breach of the loan agreement. Honestly, from a legal perspective, it's very important that you look at the terms in your agreement that are called default clause. What this means is that once it happens, the lender can basically just say, you have breached this agreement and you need to pay me back all my money, right? This could be missed payments, insolvency, breach of covenants, or even material changes in the company structure. So these are clauses that you need to look out for when entering into a loan agreement with an investor. Right. So other important clauses that you need to look out for in an investment agreement is something called a waiver of rights clause, right? So a waiver is basically a legally binding provision where a party in a contract agrees to voluntarily forfeit a claim without the other party being liable. That is what you call waiver. It basically means to waive your right. Basically means to surrender your right. Basically means to say, I dash you in simpler terms, like, oh, if I don't do this, if I don't complain about this certain act, it means that I've waived my rights. So now, waiver clause is a provision in the contract that explains what happens if one party chooses not to enforce a right or obligation immediately. Let's say, for example, I gave the example of Mr. Ade and Mr. Chuku. So Mr. Ade, on one hand, has borrowed money from Mr. Chuku, and in the agreement they said that, oh, if you don't pay me my loan back, if you don't pay monthly installments after I wait for you for 30 days, I'm going to collect all the money back from you, not even the installment payments. But however, before I do that, I'll give you a 30 days notice to pay me that specific installment that is due. And if you don't says pay me back. I'm going to give you a 30 days notice. And then Mr. Chuku does not give Mr. Ade, let's say, the 30-day notice. And Mr. Ade says, and he just keeps quiet about it. The law can actually read such a thing as waiving your rights. So waiver of right basically says what happens if one party chooses not to enforce a right or obligation immediately or as the contract has specified. So it's very important for you to look out for this term to say in your agreement. So you can either have something called a non-waiver where you say, oh, failure of me to enforce this right does not mean that I've given up the right. Or you can actually agree with your investor and say, oh, failure of any party to not enforce a particular right they have is actually giving up that right. So at the same time, it benefits the investor, benefits the business owner. At the same time, it can also be detrimental to either the investor or the business owner. But the major thing is for you to clearly define whether or not certain acts or certain non-enforcement of certain rights would constitute a waiver of your rights. Now, another thing is confidentiality clause. This clause is really important. You would see it in most agreements. It basically means that sensitive business information that are shared during and after investment must be protected and not disclosed. So what it does for you is that it prevents investors from using or leaking trade secrets, financial information, or business strategies. So founders would need to confirm the confidentiality obligations are mutual, protecting both sides, and that they continue to apply even if the investor exits. So before, as I said earlier, that before investors would drop their money in a company or buy shares or grant a loan to specific persons, they would always want to inquire into the business of that person. Like, oh, let me see your financial records. Let me see your intellectual property. What intellectual property do you have? What profits or losses have you made? Can I see your licenses? So in getting investors to trust you, there are certain documents that you furnish to their side that you send to them, just basically for them to see your business operations. So what this clause does for you is that it helps protect your rights so that even when an investor decides that they're no longer making that investment in your company, they are not sharing that information with other people, they're not taking advantage of that information in their own business. right? Another clause we need to look out for is intellectual property clause. And this is very important for startups, whether in the tech industry, fashion industry, creative industry. Intellectual property is very important. So when we say intellectual property, we're basically referring to creation of the minds, like your literary work, artistic work, design, symbols. So think about when you think Coca-Cola, I'm sure you're probably firstly imagining the bottle and imagine that red and white logo. So the intellectual properties are very important for business owners. They basically have like the trust of your company, I mean of your consumers, right? It's basically what makes your consumers your customers recognize you, your customers know your business. So it's something that you really want to protect. For many Nigerian startups, especially in tech, fashion, and creative industry, IP is the most valuable asset. So investors sometimes they want to seek rights over the IP, even trying to take ownership or use it as a collateral to protect themselves. Entrepreneurs must ensure that there is no automatic transfer of IP, and if there is, there's release of IP as collateral once the loan or investment is settled. Another clause that you should look out for is something we call boilerplate clauses. So these are clauses that are standard. You basically see them in almost any agreement. And I'll just be explaining what they mean. So even though I said they are standard, they carry a lot of weight and they require you to pay attention to them. The first one is entire agreement clause. Basically, what this ensures is that written contract is full and final agreement, preventing reliance on informal promises. So if you've written something as an agreement, you want to put a clause in it that says this is the agreement that binds our relationship with each other as a businessman and as an investor, right? But another thing you have to consider is that, okay, are we saying that if we have any oral agreements, you know, we have any oral agreement, does that mean it's not binding? Well, not necessarily. You can see contracts sometimes always have provisions where they say that if there is any agreement, you can have it in writing, send it to a particular address or send it to a particular email and shall be binding on the parties. So it's basically you just deciding for yourself what you think is best. Have I noticed that this investor likes to maybe cut corners? There's this meme online that says, talk to me direct, don't cut through corners. So you may also want to do that to yourself and ensure that the agreement that you've entered is basically what guides all of your relationship with that investor. Another thing is amendments clause. Just like this entire agreement clause, you may also make provisions to say that, okay, we can amend this agreement, maybe because we've had informal conversations and we've seen that, oh, there's a little bit that we need to tweak here. We want to change interest rate payments. We want to change loan repayment schedules because we've both seen that it's not beneficial for us. So you would need a clause that basically says that our agreement can be changed. And I would advise that it's usually required that it requires written consent from all parties. Another thing is severability clause, which basically means that if one part of your contract is not enforceable, the other part of the contract is still enforceable. Another thing is notices clause. So it basically sets out how official communication must be delivered. Remember the example I gave between Mr. Ade and Mr. Chuka earlier, where I talked about how someone said you must give me 30 days notice. And let's say in your agreement, you've already agreed that, okay, 30 days notice, send it to this particular address or to this particular email. And probably because the investor wants to be sneaky, send it to your home address that you've not lived in for like 2 years and just saying that, oh, I've already given you notice. You already know that I requested for certain things, right? So what notice clause would do is to help you set out how official communication must be delivered, which actually affects the enforceability of what is the notice that is given. Another thing is dispute resolution clause. What this does is that it basically defines how dispute arising out of a contract will be dealt with. So that's something that you really want to look out for. And that clause is something called a governing law clause. So basically what this clause does is that it allows lenders to transfer their rights under the loan to another party, such as another bank, a finance house, or even a private investor. That's assignment clause, pardon me. That's what an assignment clause does. What it just means is that parties can agree that, oh, as a business owner, as a lender in this agreement, I can, let's assume I've sold my business to someone, my banking business to someone. This person will now become your new lender. So it basically allows you to assign certain rights as a lender and as a borrower, or even as a lender and as a borrower to other parties, right? So you may want to look out for, do I really want this lender to assign his rights? Am I fine with it? What type of person is he going to transfer me to? So those are clauses that you need to look out for. Why governing law clause basically just states the law of the country that would guide your agreement, right? And it's always advisable that when both parties are in Nigeria, the Nigerian law is used for the agreement, right? Rather, the Nigerian law is agreed as the governing law for the agreement. So boilerplate terms are often overlooked, but they significantly affect how rights are enforced between parties in an agreement. Now, apart from these clauses that we've looked at in these two specific agreements, there are also tips that I would like to share to ensure that your rights are protected. The first tip is read your contract thoroughly. I think it goes without saying. Don't just skim through. Take time to understand each clause, especially around repayment, collateral, and default. So that's something that you really, really need to look out for, right? Don't just be enticed by the amount of money that an investor wants to make into your business. You also want to ask the question of um, on what terms and on what conditions am I being granted this investment? What do you expect from me? Do you have some sort of ownership stake in my business? How much do I have to repay to you? Do I give you my intellectual property, etc.? So you need to read the contract thoroughly, line by line. Put on your art, and just do the needful. The next thing would be to seek legal guidance. You want to engage a lawyer that is familiar with Nigerian company and finance law to explain the implication and spot hidden risk, right? So that's why lawyers are there. You just don't want to sign anything. You actually want to seek legal guidance. The next thing is to review in details. I mean, same thing with reading the contract thoroughly. You want to look at every term. You want to understand every term. You want to review it. Ensure that nothing extra has been added. The fourth point is to negotiate on fair terms. Don't be scared to negotiate on fair terms. Don't be scared to pitch yourself. Even though an investor is bringing something into your business, they also see potential in that business and they also be getting a benefit out of that business. Yeah, bargaining power might be different, may tilt towards the side of the investment more than it tilts towards the side of a business, especially for small businesses. But you want to, negotiate on fair terms. You want to push back on certain things. As I said earlier, don't be too enticed with what an investor is bringing into your business. There are actually serious repercussions that certain terms can have on your business. Next thing is clarity and precision. Ensure that your agreement is drafted clear, it's unambiguous. Vague clauses often create loopholes that work against the entrepreneur in dispute. So with these 5 points, reading your contract thoroughly, seeking legal guidance, reviewing details, negotiating, and ensuring clarity and precision, you have the best tips literally on your fingers right now. Next, we're going to be looking at a case study on investor dominance. And I'd just like to quickly caveat this and say that this information is based on what has been reported on news platforms in Nigeria. So we had the case of a company called 54Gene, which was a Nigerian genomic startup which raised significant funding from global investors. However, tension arose when investors led by Cartier, Africa Invest Innovation Fund, and Adjuvant Capital allegedly, based on what was reported, sidelined the founder and cut the company's valuation from $170 million to $15 million. And then they now imposed a 4x liquidation preference. They moved to sell key assets like the biobank without proper board oversight. I know that on August 1st, 2025, Federal High Court actually gave an injunction blocking these investors from selling certain company assets. But as I said, this is based on what has been reported. So we can see an example of where people that come and invest in business sort of try to take over and, introduce unfair terms to the company. So this case shows how investors can really dominate a company if shareholder or investment agreements are poorly negotiated, leaving founders sidelined, diluted, or unable to influence key decisions about their own company. So the key lessons to take out from this is that 1, negotiate investor rights carefully. understand the impact of liquidation preferences, veto power, and board composition before signing. I already emphasized on these points. Another thing is protect governance and core asset. Agreement should safeguard founders' influence and prevent unilateral asset sales. So for our conclusion, we've seen already that investment agreements are powerful tools that shape the future of any business. So while they open door to much needed funding and growth, they also come with legal obligations and risks that can affect ownership, control, and long-term sustainability. So as a Nigerian entrepreneur, the key is not to shy away from investors, but to actually approach agreements with knowledge, clarity, and caution. Always remember, read every clause, seek legal advice, negotiate fairly, protect your rights, especially around governance, shareholding, and intellectual property. By doing so, you ensure that external investment truly fuels your vision rather than taking it away. Now, with the right balance, investor partnerships can help build businesses that are not only profitable but also resilient, well governed, and positioned for long term success. And this brings us to the end of our presentation today. And without further ado, I would be open to taking our questions and providing answers to the best of my ability. Thank you.
Thank you so much, Miss Odun Ayo Ibitui. That was a very, very, very insightful session. And I hope we've all been able to take one or two from these sessions. And please, 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 if you have any questions, please indicate in the chat box so we can read it out and then Miss Odun Ayo can answer your questions. Thank you. This session today was a very, very insightful one. And then I would like you to please, whenever you have investors, please check the documents. It is very, very important for you to read your documents thoroughly before signing, because when you sign, it binds both of you. So please go to a lawyer so that you have your documents previewed. Make sure you take note of all the clauses that Ms. Odunayo has stated today, and that way you are going to be free from any legal implications when signing the agreement. Thank you very much. Yes, we'll be giving you the recordings and slides after this session. Please indicate if you have any questions. So, Ms. Odunayo, there is a question for you from John Ayodele. He said, do my written agreements with co-founders stand without any legal seal? Ms. Odunayo.
Sorry, let me read the question again.
So,
One second.
okay. Do my
Do my
written
written
agreements
with
with co-founders stand without any legal seal?
So I think the first thing that is coming to my mind is I actually want to ask, first of all, as an individual entering into an agreement with your co-founder, yes, your written agreement does stand without any legal seal, but the requirement is that your document is properly executed, which means you sign it properly. And yeah, so yeah, the answer is yes. Your written agreement with your co-founder stands without any legal seal. But the requirement is that you must execute your document properly. And by executing, I mean ensuring that your document is properly signed.
Thank you very much, Mr. John Ayodele. I hope that answer was very well. I hope your question was very well answered. If anybody has any other question, please. Okay, another question from John Ayodele. I don't get the explanation of tax on debt financing. Miss Odunayo, can you please?
Sorry, can Mr. John be more specific?
So, Mr. John, can you be more specific about the explanation of tax on debt financing?
Good afternoon. Can you hear me, please?
Good afternoon. We can hear you.
Thank you very much. During the explanation, she said, if you are going to be having debt financing into a business, that's there's a tax that should be paid for the loaned amount. I mean, it was on the slide. I was confused about it. I believe a debt should come in as a kind. It's not a profit or it's not a thing. So I don't know. It was on
Okay,
the
yeah.
slide.
Yeah, I understand your question. So I think something you really need to understand is that there's a tax that is attached to debt financing, and this is because the interest that is paid on loan is typically that tax deductible. And what this does is that it reduces a company's taxable income and consequently its overall tax liability. So yeah, there are interest that are attached to loans are usually tax deductible.
Mr. John?
All right, thank you. But is there no way around it? For example, I know that I'm extending the matter, but there are cases where maybe we're operating in a is it a tax-free setting where maybe you are just a startup or you're within your first 2 years and you don't the person financing does not want to be held. Maybe the person wants to help out in the business but doesn't want to hold his money, doesn't want his money to be held down. I don't know if you're getting the point. So a person wants to use it as a debt to finance. So in that case now, I mean, paying the tax, does it not discourage that debt financing as a means of funding the business?
Mr. John, I'm not sure I understand your question. If you could just take it again, please.
Okay. I'm saying that the purpose of debt financing, in my own view, is that the person doesn't want his fund tied down in the business for too long, maybe till when they get a buyout or things like that, and then simply wants a payout over a period of time. So, is
Sorry,
there a way around?
by the person, you mean the lender, right?
Yes, the lender. Yes, correct, the lender. So, but it seems actually hearing this tax thing for the first time, so don't mind my reaction to it. So, does that not discourage that method of financing, or to what extent can it be is it waived, if I use that word?
Okay, so my understanding is that usually when someone wants to offer like a debt financing to someone to another business, basically they would already have calculated like tax implications. They would already have calculated tax implications for the debts that they are financing. So it's really, really attached to the company's income in terms of avoiding company's taxable income. But in terms of avoiding of having to pay tax, what you would have to look out for is whether the government provides any sort of incentive for the specific business that you are granting the loan to, right? So I know that government actually gives up intensive, could be a tax break, could be a reduction in the amount of tax that you're required to pay. From the lender's perspective, maybe they want to invest in, let's assume the Nigerian government gives agro businesses some tax loans, reduces tax that is payable on certain interests for agro businesses. They may want to look into that. And I also know that, for instance, if they're operating in free zone areas, there's also like tax incentives on issues like that. So it's really typically most debt financing would involve some sort of taxable income. But as a lender, if you're trying to avoid not paying any tax or looking for tax breaks, then you would want to look at incentives that are provided by the government in that regard. So that's what I think it is.
Mr. John, does that answer your question? Mr. John? So, Miss Ruth Adesoya, your hand is raised. Do you have a question?
Yes, ma. Good
Please.
afternoon.
Good
Thank you very
afternoon.
much, Mrs. Odunayo. You have really opened our eyes to so many things. But my question now is, let's say you are a startup. You don't know much about that very business. It's not that you are a professional in that business, but there are some things maybe you can meet up in life. Maybe social conditions, economic conditions, government policy, but you've already signed an agreement with some people, and along the line something came up that you just have to shift ground. So how can we come in this kind of situation? I don't know if you understand. My unforeseen circumstances showed up that, like during COVID-19, nobody saw COVID-19 coming, something like that. And you've already signed that agreement. Is there something we can do at that point? Thank you.
Thank you so much, Mrs. Ruth. So if I get your question correctly, you're talking about a scenario where you've already entered into an agreement, let's say with an investor, and then something now happens, let's say does not allow your business perform as much and you can't meet certain obligations, and then you're asking what you would do in situations like that. Is that your question, ma'am?
Yes, ma. Yes.
Okay, so typically in most agreements, there's a clause called a force majeure clause, right? And a force majeure clause is basically a clause that says that, oh, if certain unforeseen circumstances happen, and by unforeseen circumstances happen, it's not things like, oh, family trouble, right? All of those things. It's things like, let's say, war, things like, let's say, natural disasters, etc. Things like that happen. There's a clause that actually that's typically included in agreements that would allow parties to terminate certain obligations without any liability for any party. And by liability, I mean without any consequences for any party. That's like force majeure. However, when it comes to things like business not performing well, unfortunately, obligations need to be met. So what you would want to explore is probably renegotiating certain terms with the investor and open that the investor is open to renegotiating certain terms, especially when obligations have not been met. I would advise things like transparency, showing your books, going back into your book, saying that, oh, sales were not as good as we expected. So honestly, in situations like that are not necessarily force majeure covered, renegotiation and opening conversations with your investor is an option that you would want to explore. Otherwise, it may be considered as a breach of the agreement.
Thank you, ma.
Thank you so much, Miss Odunayo. Do we still have any other question? Please, on your screen, a poll has been launched. Kindly fill the poll. Your feedback is very, very, very important to us and to help us to know how to serve you better. So please fill the poll. Thank you very much. Does anybody have any other question before we call it a day? Do we have questions? Anybody?
Hello. Hello.
Hello,
Hello.
good
Can you hear me,
afternoon,
please?
Miss. Yes, Miss Efe, we can hear you.
Good afternoon.
Good afternoon.
Yeah, thank you. So my question is a bit in a different light. Um, let's say that we are the ones that invested into a business. Okay, so I saw a business that I'm into exports. Let me use export. I saw an export opportunity, and with someone that was exporting and needed more finances to meet his client's demand, the market demand, and I invested into it. Now we had the contract that stated the terms of the investment into such, and the payable period, the terms of payment, and all those signed. And then as we went along, the export was done, but then the person that I signed the contract with here did not fulfill. What can be done in such a case besides going to court?
Okay, so when you enter into an agreement with someone, you've specified certain terms, they have obligations to meet, and they've not met it. I think the first thing I would advise is to firstly look into that contract. What does your contract say about when a party has refused to, meet their obligation? Does it amount to a default? If so, if it amounts to a default, what does the contract say? Sometimes some contracts say terminate, but I'm guessing from this question, termination may not want to be an explore. You may not want to explore termination because it then means you would have to start demanding for money, which may lead to going to court. I think the first thing I would say is if you don't want to go to court, you may want to explore alternative dispute resolution mechanisms like mediation or arbitration if you don't want to go to court. But at the same time, I understand that some people might not even want to do mediation. You may honestly want to just consider reopening the conversation, sending letter of demands to the person. First of all, ensuring that you're complying with the terms of your agreement, right? That's the first thing. Look at the agreement. What does the agreement say? If the agreement is silent on it, do you want to explore sending letter of demands to a person to meet up with their obligations as specified in the agreement? And if you don't want to go, thirdly, if you still don't want to go to court, do you want to try alternative dispute resolution to kind of resolve and see what the issue is with the person? And if not, ultimately the resort might have to be going to court to kind of get the person to fulfill their obligations under the agreement.
Okay. Thank you. Thank you.
Thank you very much. Thank you very much. Thank you very much. Please, do we still have any other questions before we call? Okay. Mr. Uzo Chuma or Miss Uzo Chuma, as the case may be.
Yes, Mr.
Good
Good
afternoon.
afternoon. Thank you for an insightful session. Is there a chance we can have the recordings and the slides from this session sent to us, please?
Please, we cannot hear you very well.
I
Please,
said, thank
would you
you
mind
so much.
taking that
Can you hear me now?
Yes, we
Can you
can.
hear me now?
Yes,
Okay,
we
I said,
can.
thank you so much. It was a very insightful session. Thank you so much. Is there a chance that we can get the recordings or the slides for the session, please?
So after this session, you'll be getting the slides for the session today and the recording too. So you will be getting that.
Thank you so much. Thank you.
You're welcome. So in the absence of no other question, thank you everybody. Thank you so much for joining today's session. We'll see you tomorrow for another insightful session. Thank you so much for joining and have a very, very wonderful day. Oh, so before we go, Miss Odumayo, I don't know if you can drop your email so that they can get legal advices, or maybe they can reach out to you for legal advices.
All right, I'll get back to you on that. Thank you.
All right. Thank you. Thank you very much. Do have a wonderful day. Thank you so much.
Thank you. Thank you, ma'am.
Thank
God
you.
bless you.
Amen.
Please, how
Thank
do we
you.
get the recordings? How do we get the recording?
We'll share it to you. We have your details, so we'll share the recording via maybe your phone number or something, or email, but you'll get it.
Okay, thank you so much.
You're welcome.